Good morning, everyone. It is Wednesday, March 24th, 2021. These are the detention hearings for the 323rd Judicial District Court of the state of Texas, the designated juvenile court for Tarrant County, Texas. In keeping with the spirit of the open courts provision of the Texas Constitution, these hearings are being broadcast live on YouTube. Recording or rebroadcasting all or part of these hearings is expressly forbidden. Violation of the court's order may subject you to civil and/or criminal contempt. All right. First on the docket is, looks like Janiyah Monet Ferrand.
Good morning, Judge.
Good morning, Judge.
Good morning, Mr. Spence. How are you?
I'm doing fine.
Hey. All right. I'm gonna let you fill that out appropriately. That one waved. All right. Is Violet here?
I'm here, Your Honor. Good morning.
Oh, good morning. How are you doing?
I'm good. I'm good, Judge.
All right. Ms. Ferrand, the law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney is here. According to the police report, back on Friday, March 5th, you were brought in because you did not come home from school and your mother reported you as a runaway. You returned about 8 p.m. 2 days later. And according to the police report, you make it a regular practice of not coming home from school until late in the evening without permission. And you've been given an opportunity to complete DPP. I will note that you've been level 1-0 since yesterday morning. So you have prior referrals for failure to ID, assault causing bodily injury, and misdemeanor theft. So Violet, what are your thoughts?
And I'd like to hear from Mom to see if she's willing to have Janiyah come home. I believe that she's done well while she's in detention, and if we need to do an anchor monitor to help her to, stay put, maybe we can try that.
Are you Mom?
Yes, sir.
All right. Well, you heard your daughter's attorney. What do you think about her coming home?
Well, Your Honor, we've been down this path before, too many times, So my thing is, once she come home, is that behavior gonna start back over again? I mean, she knows what to do in here. She knows to be still, but it's once you get home that you're not coming home from school. You stayed out on weekends. You're being disrespectful or disruptive when you get to the house. And that's not fair to all the other kids that I have at home.
How many other kids do you have at home?
5.
What are their ages?
17, 13, 12, 10, and 9.
Okay. And what kind of problems do you have with your other children?
None.
Okay. And so a young lady who is 16 and a half, who's your second oldest, we expect her to be a role model for the younger kids, don't we?
Exactly.
But she's not living up to her responsibilities, is she?
No, sir.
Okay. Let's see. Yeah, Janiyah, you had a problem this time last year. We released you from detention on an electronic monitor. You had lots of EM violations. You also had a little bit of an attitude problem in front of me. You think I don't remember these things, but I do. And you stormed out of the room in the middle of your detention hearing. And while that was a year ago, I still remember these things. And they gave you a chance on DPP, and you just think you run the show. Well, Mom, do you think she needs a little longer in detention to make sure she can follow the rules? Because she's only been level 1-0 consistently for about 24 hours. Don't you think she probably needs a little longer to prove herself before we give her a second chance?
Yes, sir.
I agree. So, Janiyah, this is where your past decisions come back to haunt you. And the way you acted a year ago in front of the court comes back to haunt you. Even though you're level 1-0 today, I'm not going to authorize your release. Instead, given your history and behavior with the court and your attitude with your mom, I'm not going to authorize your release until you've been level 1-0 continuously for 10 days. That'll be the order of the court. Thank you.
Thank you, Judge.
All
Be
right.
excused, Your Honor.
Yes, sir. Thank you, Mr. Spence.
Thank you.
Andrew Jordan Handy. Thank you, Violet. Are you Mr. Handy?
Yes, sir.
Mr. Handy, my name's Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Richard Gladstone, is here. Good morning, Richard.
Good morning, Judge.
All right. Mr. Handy,
Yes, sir.
according to the police report, you are 17 years and 1 month old. Well, month and a half now. Level 1-0 since the 14th of this month. That's good. You were referred initially last summer by the Fort Worth Police Department for engaging in organized criminal activity and burglary of a building. According to the police report, they've been dispatched to Dunbar High School after a concerned citizen reported seeing 3 men in dark clothes carrying a hammer. When officers arrived on scene, one officer observed 3 males inside the school. They noticed the young men had crowbars and were prying open lockers, taking items and stacking them in the hallway. Officers inside the building moved towards the location, apprehended you and a compadre. Immediately, the third suspect fled on foot, was later apprehended. Damage ended up being about $5,700. Wow, that's pretty impressive. All right. And your subsequent drug tests have all been negative, but the initial drug test was positive. Mr. Gladstone, does he have a parent or guardian here today?
That I don't know, Judge.
Your Honor, he doesn't.
Okay. Ms. Turner-Hill, have you been in contact with a parent or guardian?
Yes, sir, I have. Andrew he's already been placed on probation. He's just waiting to go to placement.
All right.
Yes, sir.
So, Mr. Gladstone, if I were to release him today, that would jeopardize his placement opportunity, wouldn't it? Because of quarantine?
I understand that, Judge. I mean, Andrew really wants to get out. He's very frustrated, but I understand.
All right. Mr. Handy, first of all, let me say how proud I am of you of being at level 1-0, because as a 17-year-old kid, you are a role model for those other kids in the back. And we depend on kids like you to be a good leader in the back. So will you continue to do that for me?
Yes, sir.
All right. Thank you, sir. That'll be the order of the court.
Hey, can I talk to my PO?
I'll call him,
Mr.
Your
Hill,
Honor.
thank you. All right. Thank you, Mr. Handy.
Oh.
You fill in the names. Thank you. All right. Ethan Carlos Hernandez. Are you Mr. Hernandez?
Yes, sir.
Mr. Hernandez, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And is Mr. Masick here?
No, Your Honor, he is in a trial.
All right. Ms. Smith, are you available?
Yes, Your Honor, I'm here. Good morning.
Good morning. Thank you. Mr. Hernandez, I'm going to appoint Ms. Smith to be your attorney for purposes of this hearing.
Yes, sir.
Okay. Give me just a second. waiver. All right, Mr. Hernandez. You're 16 years and 7 months. According to the police report back on November 20th of last year, you were referred by Arlington Police Department for the offense of burglary of a building with intent to enter or conceal to commit theft. Police report indicates that on that date, a little after 1 in the morning, police were dispatched to a burglary in progress at Owings Auto Sales. The security company indicated that there were 3 suspects within the fenced area of a car dealership opening doors of vehicles, looking inside vehicles. The police officer arrived on scene of the burglary in progress, observed 2 suspects who took off running when he saw them. The monitoring company told the police the 3rd suspect was hiding near a black SUV with the hood open, and police eventually found you as the hiding suspect. Then in January, we have another referral, this time also from Arlington Police Department for unlawfully carrying a weapon. Arlington Police Department gang officers were patrolling an area where several recent shootings had occurred between 2 known criminal groups. Officers observed 2 suspects with whom they are familiar, you and a compadre, who were walking in the roadway towards traffic, which constitutes a violation of pedestrian laws. Both were stopped due to your history, and you were both found with 9mm, including 1 round in each of the magazines. Then again, on February 23rd, not even a month later, you again were referred by Arlington Police Department for aggravated assault with a deadly weapon. That indicates a little before 4:30 in the afternoon on January 21st, which was before the UCW occurred. Officers were dispatched in reference to a shooting in progress at Las Palmitas Apartments. The victim reported he was walking back to his apartment from a dumpster. 1 suspect pointed a gun at him and fired 3 shots in his direction. A police lineup initially didn't pick you, but they received another lead in the case for another report, and the lead showed a match between the firearm you were found in possession of with the UCW back to a shell casing at the aggravated assault case. Well, this just gets worse and worse for you, Mr. Ethan. All right. You've been level 1-0 since February 1st. So, Ms. Smith, this is a gun crime, and I see an escalating pattern of violence. He also has a positive marijuana test back on January 28th. And Ms. Smith, quite honestly, given the escalating level of violence in this case, even though he's been level 1-0 for a month and a half, nearly 2 months, this is just way too scary, Mr. Hernandez. Okay? Mr. Hernandez, I see your hand raised. Judge Kim, I'm sure, would allow you to ask a question. I'm sure your attorney would allow you to ask a question. But if you just want to sit there and argue with me and make statements, that's probably not in your best interest. So what is your question?
I was trying to see, because I got caught on the 6th, right? I was trying to see if I could release on the ankle monitor so I could at least have an opportunity to prove to you that's not who I am.
All right. Well, I thank you for your question. The answer to your question is no. I'm going to order you be detained. Thank you, sir. I didn't sign it, did I?
Thank you, Your Honor. May I be excused?
Yes. No, ma'am.
No.
Because we may need you again if you don't mind hanging out.
Yes, sir, I am.
I really appreciate that.
Thank you, Judge.
All right. All right. I hear footsteps. There we go. Do you pronounce your first name Orion or Orion?
Right.
Orion Lee. All right, Mr. Lee, my name's Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And I believe, yes, Mr. Green is here. Anthony, say hello.
Yes, Your Honor, I'm right here at the top line.
All right. Mr. Lee, according to the police report, back on February 27th, someone called 911 due to a domestic shooting. A detective arrived and spoke with Orion's mother, who relayed that she and her husband started to argue about the younger children. The husband threatened to beat her and then leave her. You emerged from your room and told the husband that he was not going to touch his mother. The husband then asked what you were going to do about it. And so he pulled a handgun that had a strobe light attached to it. The light made everyone think that the gun was a fake. So then he became even more aggressive towards you. The mother held back the husband, told you to leave the house. As you were leaving, the husband was able to grab you a couple of times, despite the mother trying to hold the husband back. You broke free, but then, according to, okay, this gets real confusing. Ms. Brazel,
Yes,
who had the gun first, the husband or Orion?
Orion.
Okay, because the police report reads differently.
Yes, it's very confusing.
Okay, because that changes things a great deal.
Right.
Okay. So apparently you broke free, then pointed a gun over your mother and fired several shots, striking your mother's husband. All right. Do you have a parent or guardian here today?
His mother is present on Zoom, Tasha Renee de Islam.
Ah, I see you.
And the CPS investigator is also present.
Okay. Is that Varel?
Varel, yes, sir.
Okay, Varel, I need you to change your name and put CPS and give me your first and last name as your name. That way I'll be able to ask you some questions. All right. Mom, is this the first time this has happened?
Yes.
Where did he get the gun?
When he said he found it in the field by Odie White High School.
Okay. Where is the gun now?
He told me he turned it into the police when they arrested him.
Okay. Who else lives in the home with you, Mom?
My other children, and currently my husband's still here.
Okay.
He's never been in trouble, and to be honest, I probably should have gotten him counseling because he does have some form of PTSD. So I kind of feel like it's partially my fault because I never got him counseling for the PTSD because I didn't know how bad it was.
Well, are you the person who pulled the trigger?
No, but he did that to protect me.
Okay. And did you make the decision to pull the trigger?
I did not, but once again, he did.
Okay. So, whose decision was it to get the gun and to pull the trigger?
It was Orion's decision.
Okay.
But once
Okay.
again, he was trying to protect me.
Okay. That's the second decision, secondary, Mom. The first thing is we have to teach our children to take responsibility for their decisions. Now, once we've done that, we can determine whether or not that decision was appropriate in light of the circumstances. But the very first step is we have to teach our children to take responsibility for their decisions. And if we start minimizing before we get to that initial acceptance of responsibility, we don't help them. You understand? So while he may have been defending you, that's the second step in what our thinking process. First step is who made this decision. Second consideration is why he made that decision. Okay. Is your husband still in the house?
Yes.
Okay. Has there been ongoing tension between your son and your husband?
Yes and no. I mean, when he has a problem with Orion, usually he says something to me, not to Orion, but when he does, like, let's say Orion leaves a light on somewhere, or leaves a fan on in his room or whatever, or he leaves the house and doesn't turn off the electronics in his room, he'll say something to him about that, but in a really stern voice, like something that's uncalled for, personally, in my personal opinion. However,
Okay.
I don't try to get in between that, because I feel like parents should be able to parent, but I do say something behind closed doors, but not in front of Orion. If that makes any sense.
Okay. CPS, what has your investigation led you to conclude or find out thus far?
Well, so far, I don't feel that Orion should be placed back in the home for the time being. And his PTSD is from a prior domestic violence where his biological father attempted to practically kill mom, and Orion witnessed that. So I just don't feel that because there's 2 younger children at home. Well, there's actually more than 3. There's 3 right now. They are 3, 4, I believe, and 11, which he gets along fine with his siblings, but I feel that there's still going to be a lot of animosity between him and the stepdad, or at least on the side of the stepdad. And we are recommending counseling for the whole family.
Okay. Has that been offered yet?
I'm not sure if family violence is the family victim services, but we are going to offer it, yes.
Okay. Mr. Green, what are your thoughts?
Thank you, Your Honor. Orion and I have spoken. I believe what we're going to do is we're going to claim self-defense in this instant. I don't know if Mr. Haynes is on to listen.
That goes to a trial.
Yes, Your Honor. And
that's what I'm not concerned about that. Yes. What I'm concerned about is a safe place.
Yes, Your Honor. We believe there's a relative or an adult family friend that he could stay with, or if you would release him to the custody of the department so he's not in detention. Okay. It's kind of an iffy case of gun use. It's not a clear use of a crime of a gun.
Again, that doesn't go to our detention hearing. That's something completely different.
Yes, Your Honor. I'm just using it to try to show the court that he's not a danger to the community.
Well, what I'm concerned is what is the safe placement alternative? And so CPS, do you have a safe place?
I know when I interviewed Orion, he mentioned a friend that lived not too far from the family, but I still have to discuss with mom other possible placements. Not that friend, but I don't know if she knows the family or not, but we'd have to consider other friends, family, but we'd have to, of course, review criminal history and CPS history and all that and get them cleared before he could be placed.
Okay. How long do you need to make that happen?
I just need to talk to mom after this appointment, and then I can start working on that.
All right, Orion, I'm going to order that you be detained today. I'm going to order CPS. And Mr. Green, I'm going to ask you to schedule a hearing Wednesday of next week. CPS come back next week with an appropriate placement option for me.
Okay, will do.
It's your honor.
Thank you.
Thank you.
Thank you.
Yes. Yes. Okay. All right, Lanaya Murphy.
That's you?
Are you Miss Murphy?
Yes, sir.
Miss Murphy, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. That's why I'm confused. You have the right to remain silent. You also have the right to an attorney, and your attorney, Brad Shaw, is Brad? Yeah, Brad's here. How are you doing, Brad?
Doing good, Judge.
All right. Ms. Murphy, you're just turned 15 into January. According to the police report, back on, let's see, February 10th of this year, you were adjudicated delinquent for evading arrest. You were released to your mom that day, and then mom contacted the police, the probation department the next day and stated that y'all had gone to Walmart after court, and you found out that you had a phone. Mom had no idea where you'd gotten it from. You called someone to pick her up from the store. Camera footage from Walmart showed that you got into a gray vehicle. They got a partial license plate number. You apparently, allegedly took $10 from your mom's car, and the next morning showed up at home to get more money. All right. Let's see. And your March 15th UA is positive for marijuana. So, Mr. Shaw, what are your thoughts?
Judge, I'm wanting to know if her mom is here today.
She's here in the parent room.
All right.
Can I ask her some questions, please?
Yes, sir. Go ahead.
Hello, is she? I don't see her. What's her name? Lanaya's mom, are you there? Can you speak up, please, ma'am?
Gallegos.
Yes, I'm here.
Okay, so the question is do you want Lanaya to come home today?
I don't think that that's wise, no.
Okay, so was there not some type of discussion about her perhaps going and living with your mom, with her grandmother?
With my dad, yes.
Or with your dad then, her grandpa? So
Yes.
is that not something maybe we could try now to see if that's going to be something that is going to be a viable option for in the future?
So if that was to happen, I would need complete cooperation from Lanaya. She can't run away no more. We can't keep doing this. And she's stealing from us. That's not okay. I don't want her to go out there and take advantage of my parents. They are older, but they're willing to lend, to open their home to her. And the behavior that she wasn't home a full day before she ran away. I do not think that this is wise at this point. I asked for some type of monitor, something to help, and we weren't given that.
Okay, well, so, I mean, I assume that if the judge allowed her today, he could have put a monitor on her. Where do your folks live at?
In Abilene,
Okay.
by Abilene in Winters, Texas.
All right. If the judge was to put a monitor on her leg, would you have more confidence in her being released today?
I don't know. I haven't spoken to my daughter. I don't know where her headspace is. She is on medication that she refused to take before. I brought the medication here. I plan on dropping it off today. It would be more than just her saying, okay, I'm willing to go. or you're willing to go and, participate in school, not be, running the streets or meeting people and leaving, getting a hold of a phone and having someone come pick you up. Because
Okay, so then I guess essentially what I'm hearing you say is you think she needs to remain in detention for the purpose of what? Of determining whether she's serious about doing what she ought to do in the future?
Well, she put herself in some pretty hard situations. Obviously she tested positive for marijuana again. And we don't know what she was doing.
I mean, do you think she should go to placement? I mean, isn't she on probation? I think she's on probation for a misdemeanor, right?
She is on probation for a misdemeanor.
Okay, so her going to TJJD is not on the table. So, they could either send her to placement or they could continue her on probation.
I think a strict placement where she has the wording, my apologies, where it's strict. Do you understand what I'm saying? It's very structured. A structured environment would do my daughter very well.
Okay, all right. That's all the questions I have.
Thank you. Ms. Murphy, Judge Terry gave you a chance when she put you on probation in February, and your mom said you didn't even make it 24 hours. Y'all stopped at Walmart and you ran the second you had the chance. I'm not going to make the same mistake. You've got a modification hearing coming up in front of Judge Terry. So it will behoove you to get to level 1.0 and maintain it solid between now and then. Because if you don't, the argument for the prosecutor to send you to placement is going to be real strong, and you're going to make it real hard for Mr. Shaw to argue that you get to stay in the community. But I'll leave that to Judge Terry. But as for today, I'm not going to cut you loose. You're detained. That'll be the order of the court. All right. Mr. Rushton, are you Mr. Rushton?
Yes.
Yes, sir.
Yes, sir.
Thank you. All right, Mr. Rushton, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Mr. Pearson, is here. Do you see him on the screen?
Hello.
Hi, David.
I don't know.
Say hello,
Hi,
David.
Colin. Hi, Your Honor. Good morning, Your Honor.
All right. Mr. Rushton, according to the police report, you initially had a referral way back in September of 2019 for assault on a public servant, basically fighting at a lunchroom. A resource officer tried to break it up, and then the resource officer got hit. Then more recently, the end of last month, you were referred in custody by the Fort Worth Police Department for the offenses of aggravated robbery, 2 counts of robbery, and interfering with an emergency call. According to that report, around 6:30 in the evening, officers were dispatched to the first victim's home, who reported that a young man wearing a black hoodie and sweatpants had knocked on the door and informed the victim that he was being robbed when he answered the door. The suspect told the victim to go back into his home and get him some money. The victim closed the door, locked the door, contacted police, and then the suspect fled on foot. The victim was over 65 years old, and hence the aggravated robbery charge. Officers also received a second robbery call nearby and spoke with victim number 2, who is an employee of Cricket Wireless, and she reported that a young man wearing a black hoodie, sweatpants, and red shoes came into the business, pointed a stick at her, told her she was being robbed. She tried to call 911, but the suspect grabbed the phone from her, disconnected the call, and fled the scene on foot. Officers spoke with her and the suspect, who they later identified as you, who had returned to the store. Oh yeah, felony stupid. Okay. All right, Mr. Pearson, what are your thoughts?
Well, Your Honor, his mother, I don't know if whether she made it to the link or not. Carletta Rushton is very interested in bringing him home. She's been in contact with me this morning trying to get, she couldn't get there in person, but she could get there to pick him up. He has a psychological schedule. I think the family he has mental health history, recent mental health history, quite a bit, actually, hospitalizations. I think if he was under supervision on a monitor, if he made that psychological evaluation, then we could be on track to handle this case. It's set for a contested hearing in April.
And when is the psychological evaluation?
It's the early part of April, I think the 6th.
Okay.
It's actually scheduled for April 2nd.
Okay.
Oh.
Thank you, Ms. Paxton.
You're welcome.
All right, Mr. Rushton, I will note that you have been level 1-0 for a good time. However, given the referral back in 2019 and the escalating level of violence, I want to make sure that we get that psychological completed in a timely fashion. I also think that right now, if I were to release you, you'd be a danger to the community or yourself. And so on that basis, I'll order you continue to be detained. We'll reevaluate this in 10 business days, and we'll see how it goes then. Thank you, sir.
Thank you, Your Honor.
Cameron Sales.
Thank you.
All right, are you Mr. Sales?
Yes, sir.
Mr. Sales, my name is Judge Porter. The law says when you're brought into detention that you must see a judge within 2 business days to determine whether probable cause exists to believe that you've engaged in delinquent conduct to warrant your initial detention, and then to decide whether you should continue to be detained. If I order you to be detained, you will have another detention hearing every 10 business days. At this hearing, you have the right to remain silent. You also have the right to an attorney. I've appointed Trent Lofton to be your attorney. Good morning, Trent.
Your Honor, I believe that I'm the appointed attorney. For
You're
Mr.
right. I skipped a line. I apologize, Mr. Beaver.
I'm next, Your Honor, so.
I'm sorry. I'm trying to read 3 different pieces of paper at the same time. I skipped a line. You're absolutely correct, Mr. Beaver. I apologize.
I'm not a cat, Your Honor. I'm sorry. I just always wanted to say that.
Straight face. All right, Mr. Sales, I've appointed Mr. Beaver to be your attorney. All right, according to the police report, let's find out what's going on, Mr. Sales. And before I get there, okay, drug test is negative. Mr. Victorson, does Mr. Sales have prior referrals to the department?
Yes, Your Honor.
I was going to say, why do I know that name?
Well, no, I don't think he has prior referrals, but he has a brother. Let me double check though.
Is your brother Quentin?
Yes, sir.
Ah, that's why I recognize your name. Okay. So this is his first referral, Mr. Victorson?
Yes, Your Honor. Well, this is actually an electronic monitoring violation referral, but the original referral is his first.
Okay. So last month you referred 11:30 at night. Police were dispatched to a robbery at a 7-Eleven. When they arrived, witnesses pointed to police in the direction of where the suspects had ran. Police observed about 6 males matching the description of suspects standing in the Kroger parking lot, which is directly behind the 7-Eleven. 5 of the 6 suspects fled on foot when they saw the police. Police gave chase, telling stop, police, and detained all of them a short distance away. The suspects had items on them that had been taken from the 7-Eleven, including alcohol and candy. The 2 7-Eleven clerks told the police that the 6 suspects came into the store and 1 went to the restroom. He then exited the restroom and all the suspects left. A short time later, all suspects returned and all entered the 1-person restroom. The clerks could hear the air dryer working and told the suspect that he needed to leave if they weren't going to buy anything. One of the suspects told the clerks something that is not appropriate to broadcast over YouTube, but involves some colorful language that would constitute a terroristic threat if committed by an adult. The clerk said that he was calling police. One of the suspects then threatened to kill the clerk and the cops if they showed up. At that time, the suspects then began assaulting the two clerks, hitting them each 2 to 3 times in the face. Suspects grabbed a bunch of items and exited the store. All right. So, Mr. Victorson, tell me about the electronic monitor violation on the 23rd.
Well, he was released from detention after 3 days of level 1-0 on the monitor on the 25th of February. And then on the 13th day of March, we got an alert saying that he left the home at approximately 1:40 a.m. and returned home at 2:05 a.m. We then asked our vendor to certify that alert as accurate, and they did so. Once we learned that that was certified, a directive to apprehend was generated, and I notified the family yesterday, and Cameron turned himself in to the juvenile probation department about 5:30 last night.
All right. See if the parent or guardian here today. Mom,
Yes,
what's
sir.
going on?
No, sir.
Cameron was our good kid.
Cameron is a good kid, and I don't agree with the monitoring because of where my house is at. Cameron was not gone on the 13th. The only time Cameron had left the house was on the 12th, around 1:12 in the afternoon. And that was us, me and him and myself in our carport washing my car. Now, the problem that I have with the monitor is because where I live at, I had the same problem when his brother was on the monitor. It would ding that he wasn't there when he was there. I usually would get a call from the intake officer or something like that, and the intake officer would actually, ask to speak to my son to verify that he was there. In this case, this time, it didn't happen for Cameron's situation. I also, right before his probation officer went on vacation, I had received a call from Mr. Dana stating that, asking because it was a ding that Cameron had left, but Cameron was right there in front of me. So he said that he had, was going to talk with them about, about that because I had brought up that situation about the ankle monitor. Now, when his brother was on the ankle monitor, they were saying something about they did a Google Maps or something like that, and somewhere about where my house is because it's on a service road of 35 in Alta Mesa, and it's like nothing but freeway, and just a lot of stuff that they were saying it was dinging. It was something that was causing a problem. So I'm not, trying to justify anything, but I know for a fact he was there. He was there because I was there.
Yeah, but we had lots of
That's
problems.
the thing, though. It's really not fair because I usually would get a call or something to verify, and I don't. All I have right now is just my word to tell you that he was there. I can't, what I'm saying, I don't have a backup of intake officer or someone that usually would back up that call, and then I would give the phone to my son for my son to say, yeah, I'm here. So, that's the only time that he was actually out of the house was Friday afternoon around that time.
So you're telling me that when this alleged monitor violation occurred, y'all were out washing your car?
No, negative, sir. That's the thing. I had actually got confused because, mind you, I just found out about the warrant or anything on just when I turned him in yesterday. Okay, when I got up from my nap yesterday, I saw an email from a message from his father saying to contact him because he had contacted Mr. Dana to try to figure out how we can, because he's supposed to get him every other weekend. So how can, when he get him on his weekends, when he goes over his house, that it dings, that he's at his dad's house. Mr. Dana explained to him that he wasn't going to be able to do that because he just looked at the paperwork seeing that Cameron had a warrant. He just got back from vacation that Monday. So this happened on the 13th. I don't find out anything until the 21st. So he's got a warrant out from the 13th to the 21st, until I brought him in yesterday. And I truly know for a fact that Cameron was at that house with me. And I felt really bad because I thought that it was my fault that he's gotten in trouble with this ding because of me letting him wash the car with me that afternoon. So I thought that the times was mixed up. But at 1:30 in the morning, we was up at the house. We wasn't outside in my carport washing no car, but we was at the house. And the thing is, sir, is that Cameron has been doing really well at that house. He has not left. He's been making up his homework. We've been doing conferencing with his teachers and stuff so we can get him up on his 2 subjects that he was behind on that he has to pass in order to graduate. So he goes back face to face.
I'm going to interrupt you. I'm sorry. I'm going to interrupt you because
I'm just trying to save my kid that I know for a fact was in the house. And all I can do is, that's my word. I don't have nobody else to verify that.
Were you asleep at that time?
Negative.
You were up?
Yes, I was. That's why that was the trip, because we're up late like that. And we're sitting there watching TV. And the reason why I know for a fact is because Cameron was on his phone FaceTiming in his room. And his room is facing the freeway right there off the service road. So I mean, you know.
All right. Mr. Victorson, what does a certified EM violation mean?
It just means that the vendor would come to court and dispute any concerns that it's not accurate, and that they have evidence in their science and how the GPS works, and that they would state under oath that it's accurate.
Okay. And how far away would Mr. Sales have to get before it registered a violation?
I don't know the answer to that, Your Honor. My understanding from talking to our EM staff was that the GPS indicated that it looked like he walked around the block.
Okay. All right. Cameron, I'm going to order that you be detained today. You know how to get to level 1-0. You know what that means. And we'll reconsider this in 10 business days. All right. Thank you, Mr. Beaver.
Thank you, Your Honor.
All right. Jordan Malik Taylor. Are you Mr. Taylor?
Sir.
All right, Mr. Taylor, pull your chair closer to the computer for me. Pull it closer than that. Pull it all the way forward. There we go. All right, Mr. Taylor. My name is Judge Porter. The law says when you're brought into detention, you must see a judge within 2 business days. You have the right to remain silent. You also have the right to an attorney, and I've appointed Trent Lofton to be your attorney. You're 14.
Good morning.
If I decide that probable cause exists to believe that that your initial detention is lawful, then I can make the decision of whether or not you should be detained. If I order you to be detained, we will have another detention hearing every 10 business days. All right, Mr. Taylor, you're 14 years old. You were brought in by the Arlington Police Department for the offense of evading arrest with a vehicle and unauthorized use of a motor vehicle. According to the police report, officers were conducting speeding enforcement at 360 and I-20 and noticed a white Ford Edge with temporary tags and front end damage traveling an estimated 90 miles an hour in a 60-mile-an-hour zone. Officers attempted to stop the vehicle by activating their overhead lights, but it began to evade them by not stopping and driving erratically. Officers reported that the driver was a young man wearing a gray hoodie. The Ford then exited the freeway and cut through a gas station, almost striking a pedestrian. The Ford continued driving erratically, so the pursuit was called off by commanding officers, but officers continued to observe the vehicle from a distance. Officers requested that the pursuit be initiated again after the Ford was again observed driving as high as 90 miles an hour on New York Avenue and making illegal U-turns. Shortly thereafter, there was a report of an accident involving a white Ford. Officers arrived on scene and saw that it was the same Ford that had been involved in the earlier pursuit and that the vehicle was totaled. Witnesses described a young man wearing a white t-shirt and a gray or blue jeans pants exit the driver's side of the Ford and run away. Officers began searching the area and they found a young man matching the description given by the witnesses and put his hands up in the air and laid down. And he was identified as you. And you admitted being the driver and the only occupant of the car. You also asked the officers to retrieve your belongings from the car, which included a gray hoodie, which matched what the officers first saw you wearing, as well as a backpack, a phone, and a pair of sandals. Police confirmed that the Ford was a stolen vehicle, but the initial report did not include the victim information. All right. And this is your first referral to the department. Do we have a parent or guardian here?
Yes.
Yes.
All right, Miss Taylor. Wow. So, Miss Taylor, is this the first time you've had problems out of your son?
This is the first time that something, well, like he's had to go to Kimbo or anything for this. This is not the first time something like this has happened. I want to say it's like the second time, but the second time, I think it was the Grand Prairie Police Department brought him home.
What was that for?
Same similar incident with a car, a stolen vehicle.
Oh. Mr. Lofton?
Yes, sir.
I bet you got some better questions for Mom than what I had.
If it pleases the court, ma'am, so what is your opinion right now? What do you want to happen?
Right now, I'm currently thinking of sending him with his dad to Houston for a little while because I work, so I'm not, and he has 4 other siblings at home, so I work and I'm not there often with him, and I think he just needs some more supervision. And I believe him going to go stay with his dad would be a better decision for him right now, so that he can get some more one-on-one time with his dad, and he can get some more time spent.
Do you understand, even if the court were to let him go home today under your supervision or his dad's, he still has at least 2 cases pending under the jurisdiction of the 323rd District Court in Tarrant County?
Right.
And would you assist making sure he gets here to do anything he needs to do if he were released?
Yes, I would.
Yes.
Can y'all hear me?
His dad's on the line.
I'm sorry.
His dad's on the line too.
Okay, I'll be quiet, Your Honor.
Not your turn.
I passed any witness, Judge. I'm sorry.
Okay, Mr. Henderson, you can't talk out of turn. You have to wait until the attorneys talk to you, okay?
Yes, sir. I didn't know if y'all knew I was here or not. That's all. I apologize.
All right, Mr. Lofton. All right. Mr. Taylor, 90 miles an hour and a 60 in one location, almost striking a pedestrian, 90 miles an hour again on New York Avenue, totaling the vehicle, and this is your second rodeo? No, sir. You're not going home today. If I were to release you, you'd be a danger to the community. So perhaps next time, but not today, sir. The danger you pose to the community is too great to let you go today. Thank you, sir. Micaiah Vet Walden.
Thank you, Judge.
Ms. Mills. Okay. Are you Miss Walden?
Yes, sir.
Miss Walden, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And is Miss Mills here today? I did not see her.
I didn't see her, Your Honor.
All right, Miss Smith, do you mind stepping up again? Ms. Walden, I'm going to appoint Ms. Smith to be your attorney for purposes of this hearing. All right, back on February 9th, a directive to apprehend was issued due to you violating your electronic monitor and leaving home without permission. 2 weeks later, you were brought into custody for the violation of the electronic monitor. And you have a pretty lengthy history of referrals to the department, including an extension with placement. Wow. All right. Those prior offenses include criminal trespass that were waived, theft that were supervisory caution, unauthorized use of a motor vehicle for which you've received probation, an assault which was dismissed based on a not true finding, and then the modification with extension. Ms. Burrell,
Yes, Your Honor.
what was that placement for?
On January the 13th, you actually did her motion to modify, and Micaiah was just pending placement at the time. They didn't have available until April, and they do have a bed available now, so she will be transported on April the 12th.
April what?
12th.
Okay, okay. That's the bad news. Micaiah, here's the good news. What's your level in the back?
A 1-0.
How long have you been 1-0?
28 days.
Well, how long have you been consistently 1-0? Like not dip down to 1A, but consistently 1-0.
I don't even know.
More than 2 weeks though, right?
Yeah.
That's really, really good. All right. You know I can't release you today, but the good thing is we've got that placement bed lined up. Ms. Burrell's gonna have you at a great opportunity, and so we'll make sure that happens for you, okay?
Okay.
All right, thank you. Thank you, Ms. Burrell. Felicity Willingham. All right, are you Miss Willingham?
Yes, sir.
Miss Willingham, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And Violet, are you still here?
I am, Your Honor.
Oh, there you are. Okay. Okay. And is CPS present today?
Yes, Your Honor. CPS and Lakeisha Willingham, Felicity's mother, are both present.
Okay. I see Miss Willingham.
CPS is under Mona Lisa Evans.
All
CPS.
right. All right. Miss Evans, can you bring me up to date on what your department is doing? You're on mute.
There we go. Can you hear me now?
Yes, ma'am.
Okay. All right. We are just waiting to see if you all will be placing her in a locked facility for treatment. That's our recommendation, that she go to a locked facility. We spoke with Mom yesterday and she seemed willing to participate in anything that we offer her, but we're not certain that if Felicity returns home, she would remain home. She has a history of running away, so that's our concern at this point.
Ms. Castillo, what were the results of her recent drug test?
She tested negative, Your Honor.
Okay, and was that drug test administered this month or the one back from January?
It was when she was referred into the department. I believe it was, let me check on that. It was on this last referral. It took her a few days to provide that. Yeah, that was back in January the 12th.
Mm. Okay. Ms. Willingham, if you could turn on your microphone. You know your daughter better than everybody else. And if I were to release her today, would she run away?
I would say she probably wouldn't do it the first day, but it will come very soon.
Okay. And are you worried that if she did run away, something bad might happen to her?
Yes, very much so.
Okay.
Your Honor, I would also note, though she's level 1 and has been level 1 since March the 4th, she has received minor infractions. As recently as yesterday, she received 3.
Well,
Might say something.
yes, Violet, please.
I believe that she's been here really long enough for Felicity to learn a few things. We will never know until we give her the opportunity to prove herself. I really believe that there could be a change this time around, and I'm asking that if the court pleases to release her on an ankle monitor, and we see Felicity already knows that she doesn't want to be here. She doesn't want to be in detention, and she knows what can get her here really fast. So I'm just pleading with the court to give her an opportunity to prove herself that, she has learned one thing or the other over the course of several weeks that she's been in here. And I do know that Judge Terry requested that CPS, the OCOK, be present for this hearing, but I really don't see any available placement for her soon enough. Usually it takes several weeks to get these things done. And I don't think that she's getting any help in detention at this point.
Okay.
And she's slated to appear, Your Honor, before your court on Tuesday.
Yes, ma'am. Yes, ma'am. Ms. Willingham?
Yes.
Your attorney's, I'm sorry, Felicity, your attorney's arguments are well made, and she's got some really, really good points. But I have to weigh against what your attorney's arguing, and she's very eloquent in what she's saying. I have to weigh that against what your mom says. Your mom knows you better than everybody else. And I'm also looking at your history over the last year. And I'm just concerned that if I let you go today, you won't be here for court on Tuesday. So I'm going to order that you be detained. Maintain level 1-0 between now and next Tuesday, though, okay? Because that will factor into my decision on what I do next Tuesday, okay? And if you maintain level 1-0, you put yourself and your attorney in the best possible position to argue for the best possible outcome for you. It'll also go a long way in showing mom that you are serious if you really do want to change. If you can maintain level 1-0 between now and then, that'll mean something to your mom. It'll show to her that you can follow the rules and that you do want to be a good kid, okay? And those are the things you want to do, right?
Yes, sir.
All right, that's going to be the order of the court. Thank you.
Thank you.
Thank you, Mom. Thank you, Violet. All right, please don't bring the next kid in. All right. Actually, that will conclude all but the last detention hearing, which we are doing in person. So I thank everybody for watching. I'll remind you that rebroadcasting or recording all or part of these hearings is expressly forbidden, and that violations of the court's order may subject you to civil and/or criminal contempt proceedings. With that being stated, I wish you all a great day.
Judge, what about Isidra Tristan?
Raphael,
Yes.
are you his attorney?
Isidra Tristan, yes.
They're doing him in person. Are you here?
No, I'm on the web.
Okay, well, they're doing his in person.
Well, no one gave any notice that it was going to be done in person either.
No, he didn't know.
No, nobody gives notice.
Yeah, I can.
So why are we doing web for every single individual except this one?
I have no idea. I just checked, and I just kind of wanted to put you on notice. I can go and see if we have an attorney, somebody here to represent him, but.
Well, no, I'm here. I'm present on the web. Why are we doing things differently? It doesn't make sense.
I can let the judge know that you weren't notified.
I wasn't notified, and I'm here, able and willing, and I've been waiting. I got the email to get on the Zoom. So
maybe I can I'll try to take my computer.
Yeah, Miss Stephanie send me the email to get on Zoom. Those were the instructions.
Raphael, are you there?
I'm here, Judge.
All right. Okay. Are you Miss Tristan? All right. You got the air conditioning turned on, and it's right above me. You got to talk louder than that. All right. Ms. Tristan, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right can you see Miss Tristan on the screen?
Yes, Your Honor.
Raphael?
Yes, I can, Your Honor.
Oh, hold on.
Yes, I can. Yes, I can, Judge.
Hold on. If you don't mind, yeah, because I'm not going to be able to hear.
And Your Honor, really quick, do you need me for these hearings?
No, ma'am, you're good. I appreciate your help today, Ms. Smith.
No problem. Thank you, Your Honor.
Okay. Do you mind turning on your video camera? There we go. All right. Raphael, can you see Miss Tristan okay?
Now I can.
All right. Okay. Positive UA for marijuana on February 18th. Referred by APD on the 17th of February for DTA. You're pending an assault causes bodily injury, family violence, and interfering with emergency call. Ms. Cook, does she have a parent or guardian here today?
She does not. However, Mom did say that if you just release her today, she can pick her up afterwards.
Okay. And she completed her forensic interview?
She did. And she had her psychological on Saturday or Sunday. The report's due back next Monday. And she has a physical exam with Cook Children's because of the forensic interview on Tuesday next week, which Mom again has said that if you release her, she will take her to.
Okay. Has she been on an electronic monitor before?
She has 3 times.
How'd it go?
She cut it off all 3 times. This is the longest she has been in detention, and she has been on level 1 since March 11th.
Oh, Mr. Sierra. She's cut off her monitor 3 times. What am I going to do? I want to let her go.
Judge, I would have to defer to the court under these set of circumstances presented.
You're killing me. You've been good for like more than 2 weeks. And so if it were any other kid, and you're 13, any other kid, I would let you go. But you cut it off 3 times. At what point do I have to say, I can't trust you anymore? I think I'm at that point. I can't trust you. You don't want to say anything. You don't want to say anything. Oh, man. I'm serious. A 13-year-old young lady who has been level 1-0 for this long, but I can't trust her.
Your Honor, if I may, I have been thinking we were headed towards placement this whole time since she cut it off again. But I will say, I asked her last week on the phone, or maybe 2 weeks ago, I really need you to show that you can show positive behavior, and she has done that since March 11th. She is set with you on April 13th, and I feel like if she goes home, we put yes waiver in the home immediately. They've already started, but they haven't started. She's already, that's her last ditch effort to show that for 3 weeks before her court hearing, she can stay home and do the yes waiver, because otherwise we are sending her to placement. And are we there with 13 years old and has had no service in the community? But that's because of her choices of continuing to cut the monitor. So.
Judge, may I ask if Mom was willing to take her? I didn't hear her.
Ms. Cook said that Mom is willing to take her and also willing to take her to Cook's Children next Tuesday for her appointment.
Gotcha.
I look into your eyes and I know that the second I let you go home, that it's just a waiting game until you cut off that monitor? The question is, do I want to give you that chance anyway, knowing that if you cut it off, you're going to leave your attorney, me, the prosecutor, with no choice on the outcome of your case. If you're found to have engaged in delinquent conduct, you're going to leave us with no choice but placement. Do you understand that? Let me ask you this, because it took 2 weeks between the DTA and the time she was actually turned in.
Yeah, she cut it off to February 17th. No, I'm sorry, that's the day she came in. She cut it off February 8th, and she came in February 17th.
Okay, so 9 days. So let's give you a little bit more credit this time. Let's say you cut it off and you're on the loose for 18 days, twice as long this time. That 18 days of having cut off the monitor is going to cost you 6 to 9 months at placement at a school in Iowa or Arizona or maybe Michigan. Is 18 days worth 9 months away from your family? Where, let me do the math. Oh yeah, you're going to spend your 14th birthday away from your family. Is 18 days of cutting off the monitor worth spending your 14th birthday and the next 9 months away from your family? Okay, you say that now, but when the opportunity comes, are you going to make the same decision? You only have 3 weeks between now and your hearing. 3 weeks. Can you make it 3 weeks without cutting your monitor off? Okay, tell me what you're going to do to cope with the stressors at home so that you don't have the desire to cut off the monitor. Okay, I need you to talk a little bit louder, and I'm going to turn on that microphone. Okay, talk a little bit louder and talk into the microphone. Raphael, can you hear her? Okay.
No, Judge. I mean,
Okay.
I can hear the mumbling, but I can't hear it with clarity.
Okay, down and talk directly into the microphone.
When I get mad, I'll go to my room or I'll write or listen to music.
Could you hear that?
That she goes to her room and that she will write things down?
Write and listen to music.
Okay.
Okay. Do you have access to a phone at the home?
No, my mom doesn't need no.
Okay. Okay. We're talking 3 weeks until her. You got to make it. You really have to make it 3 weeks. If you don't, I'm going to be out of choices. Is she taking meds in the back?
She is.
Okay. Okay.
That was the big thing the first time, is she has not been on medication, and we wanted psychiatric and all that. So she's had that.
When did she see the psychiatrist?
She hasn't. I mean, she saw them the last time she was in detention back in January and started medication.
Okay. Mr. Sierra, will you get with mom? Because she's due for probably another psychiatric appointment.
Mhm.
And would you or Ms. Cook convey to mom that she really does need another appointment?
She's with Yes Waiver, and so they do coordinate back and forth with MHMR with that.
Okay. I'm concerned her dosage is messed up. And that's just from talking to you. It's the dosage is working, and I'm not a psychiatrist, but I know a little bit about medication, and I'm thinking it may be a little strong for her. Do you feel a little foggy? Yeah. Yeah. And how long does that fogginess last after you take your medicine? Okay. So it's not until after you've eaten breakfast that it clears up a little bit? Lean into the microphone. Uh-huh. At 6 in the morning? Yeah. And then you take your nighttime meds at what time? Okay. And so around 8 or 9 that you start feeling sleepy? Okay. Yeah. Okay. Did you catch all that, Raphael?
Yes, Judge.
Okay. You can't cut off your monitor. Okay. This is not your first, not your second, not your third chance. This is your fourth chance. Okay? I normally don't give kids fourth chances. But Ms. Cook says you've been doing a whole lot better. I'm going to give you this fourth chance. But if you burn me, I'll be without options. You understand that? Yes, sir. All right. I'm going to release her on the electronic monitor, Mr. Sierra. She's got a doctor's appointment at Cook's on Tuesday of next week. Mr. Sierra, if you can coordinate with Ms. Cook and mom to make sure she gets that, and then follow up with Yes Waiver. All right. Thank you, everybody.
Thank you, Judge.
You have your own.
I've got an EM release. Well, if you got it, yeah.
Okay, but if she